Caillou, come on in. Caillou, come on in. Share with a friend. Share with your family. Let's share this information. Broaden your horizon. Let's do this. Let's go. Kayuk, everyone. Good morning. Good morning. Happy Monday. Happy Monday. All right. So today we're going to jump into more details about the Commonwealth of Virginia. First, they illegally terminated a people, and now they're tampering with the scales of justice. Okay. And we're gonna bring everything up to date to what is happening with them and what they're doing. Basically, what is our stance? How am I standing up against this? What is actually being done and what they're doing, and how they use what we don't know against us. So what you don't know about your rights and what you don't know about the law, they use against us. And they assume that we don't know. But the other thing that they assume that we're not intelligent enough to pick up on things at a extremely rapid rate, which is very, very foolish of them not to realize that whatever kind of sorcery they use to try to make the justice system that we develop more complicated is in vain. Like that's just not going to work against us. And to think that bullying, intimidation, terrorism are the tactics that the Commonwealth of Virginia would use via Jack A. Thornton III is very sad to me and very disgusting. It's very disgusting and sad that they would go to such a low depth. But what it does reveal on the bright side is that that's how strong our rights to our land is, that they would stoop, and they do stoop, and they do continue to operate at such a desperate and dirty, dastardly, corrupt level. Like, you would corrupt your career because that's how much power there is that supports our land return. You would actually corrupt your career to try to stop this. Wow. Wow. Well, when it's time, it's time. And it's time for the land to be returned. It's time for their time is up for their lies and their corruption, and it's over. And there's really, there's not another lie you can tell to make a lie the truth. You can't keep, no matter how many lies you tell, it is not going to make the lie the truth. Now, the power of the lie is that it is believed. Our belief in the lie is what gives the lie strength and viability, right? But once you know that what they're teaching us and what they are putting out there into the stratosphere are lies, it falls apart, it disappears, it collapses. And this is the collapse. Rome has fallen. Rome has fallen. Okay, let's go look, because yesterday I went over a few things that some people might not have seen. I don't know some people are back. Hi, how you doing? Yes, light, peace, light, and abundance. Thank you. So, what did I do yesterday? Yesterday I went to, we started there. Let's start out looking at how, they like to paint a picture. They like to paint a picture in a way that disparages, that gives a negative light, that paints, this thing and to their advantage, right? So, they call it fraud. Well, the paper, you can't call a quitclaim that has been civilly litigated in 2 cases a fraud. It's not a fraud. If it was a fraud, it would have been removed from court immediately. Like it would have been a frivolous case, right? It would have been frivolous. This is a case that went on for over 2 years. This is not a fraud. What it is not is a fraud. How can they call something that was in federal court, U.S. federal court for over 2 years, a fraud? This is not a fraud. So the newspaper does defame me. The newspaper, Shore Daily News, does defame me. And we have footage of the fact that they, interviewed me when we had a Unity in the community event, and they came in and interviewed me. I went to their associate radio station and gave an interview at that time, around that time, several years ago. So for them to sit up there and call me a fraud, that I'm doing fraud by claiming what they know to be our ancestral land, they know it to be Indian land, but then what they want to say is that the Indian be dead, be gone. That's what they want. They want to declare the Indians gone, disappeared. They do not want to give it to the real Indians that are still here, that never went anywhere. That is a violation of their lies, right? That contradicts their lies. That's a problem. That the Indian is here, alive, well, present, in good form, and ready to take back what has been stolen. Oh, now we have a problem. Now the stories are not lovely and cute. Now we don't revere the stories and put up little guidelines so you can find the plats. Here, find the plat. Look it up in the courthouse. Oh, isn't that cute and lovely? It's cute and lovely when the Negroes don't know that they're the Indians and they don't declare it and they don't claim what's theirs. Yeah, it's cute and lovely when the Indians are some kind of defunct make-believe beings. When the Indians are real life people that are the Negroes and they know it, that is when it becomes a problem. That's when their made-up history is no longer cute and fascinating and fun. Oh, isn't it cute? Oh, isn't it so cute? It's so cute. No, it's not cute when Lisa Cypher stands up and says, yo, these are all my ancestors. This is all my people. This is our territory. This is our patents. You're on our land. Something must be done to correct this. Oh, now it's no longer cute. Now you're a fraud. I'm a fraud in what? A fraud in claiming what is rightfully ours? You didn't think I was a fraud when I was in federal court for 2 years. You didn't think I was a fraud when you brought me in court in October in a civil case. You thought I was the real deal. Why would you sue me for $300,000 if you didn't think it was a legit issue? And also, that was dropped, by the way. Stop this game playing in malicious persecution. Jack A. Thornton III. This is disgusting. Who does this? Come on. Let's go to the next thing. Let me tell you about how this is okay. So when you go to things like the Library of Virginia, and they have a whole thing called the Gingaskin Indians. Now see, y'all gotta understand. Why does anybody care about the Gingaskin Indians so much, right? Why do they care about it so much that it's, a topic of discussion for, all of this, the Commonwealth of Virginia's library, the Library of Virginia. Why? Because when you start unpeeling this, when you start going down this rabbit hole, you realize that the Gingaskin are the Accawmacke, are the Powhatans, are the Accawmacke all the way up in Maine. We are a huge empire. And that's why all the name changes. It's like changing from colored to Negro to black to African American. They have to do that whole thing where they do the 3-card Molly, where they changing your name. You don't know where the daggone money is, right? That's why they talk about the Gingaskins. Why is it so interesting? Because we are the Powhatan Confederacy. We are the people of Powhatan. Powhatan was born a Gingaskin, Accawmacke Indian, and Accawmonteses. This is a huge issue because the land that we have patented is not just in Virginia, not just on the Eastern Shore. It goes across the countryside, all the way up to Canada. We're huge. And I didn't know that. Only reason I know it because they keep fighting me. And because they keep fighting me, I keep learning and researching more. And I'm like, oh, crap. Ooh, this is big. This is big. Why do they make it so clear? Why did they not get rid of the pomote or the Rappahannock? Or because they were inconsequential. They were inconsequential, tributaries to the Accawmacke. They were not the Accawmacke. The Accawmacke are the people, are the folk. We the folk. We the empire. We're the organizers. We are the organizers. There are other nations, so many nations that are organized into the Confederacy, but the organizer of the Confederacy are the Accawmacke. That's why we had to go, and they celebrated, and they write all about it everywhere they can, and they write that, oh, we were legally terminated. Oh, really? Pass a law to eliminate the reservation and divide it. The General Assembly. The General Assembly. Okay. So the General Assembly, they got that juice to do that. Virginia General Assembly. Okay. They actually tell you that the General Assembly has that power. Well, they don't tell you that, but we all assume it, because why would the Library of Virginia and all these entities lie to us? Why would they lie to us? Right? Right. Why would they lie to us? All right. So let's talk about that. Why would they lie to us? All right, let's look at this. The Non-Intercourse Act. Let's go look at this. It's not loading because you know they don't want me to show some of this stuff. Load up, baby. Load up. Okay. Where is the non? All right. It's not loading up. Let me try it. All right, we'll just look at this thing again. All right. So like this is showing that at the beginning it was Virginia and Florida. So Virginia went all the way into Canada and all the way out to Dagon and Mississippi, Ohio, all that stuff. Mississippi, Ohio, Illinois, all that, you know, Alabama. Virginia went all over, right? Florida went all over, went all the way out past Louisiana. So it was in the beginning, that's what it was. So you got to understand the territory that our chiefs at that, when they arrived here, the Confederacy was vast. Okay. That's the thing. We got to have that kind of understanding. Okay. Now I'm going to try to go get that Non-Intercourse Act. Okay. Here we go. Okay. Now they got the Non-Intercourse Act and they stop it in 1810. No, they started in 1810. That's not true. Even if it was 1809. Okay. It's just are they writing about the right? Oh, they're writing about it in a way that's not the Non-Intercourse Act. That's not right. All right, so let me do this a different way. The 1790 Non-Intercourse Act is why you know that Virginia is lying, okay? Virginia is defrauding, okay? So if you Google the Non-Intercourse Act of 1790, right, passed by the United States, right, the Indian Intercourse Act or the Non-Intercourse Act, all right, okay, let's go to share this tab. Okay, so we're going to see it. Okay, so that's the Non-Intercourse Act, all right. When we look at the Non-Intercourse Act, we see that it is the Indian Intercourse Act or the Indian Non-Intercourse Act. And what it really says is that states don't have power when setting boundaries about the indigenous nation, regulating the indigenous nation, or and it prohibits the purchase of Indian lands without the approval of the federal government. And it originates in the Royal Proclamation of 1763, right? So there was a Royal Proclamation in 1763. Then there was this Non-Intercourse Act. Then there is a follow-up Non-Intercourse Act, right? And then there's another act, right? Swiss Act. So there are several U.S. acts that does say you can't divide up. States don't have that authority. So the fact that on this website over here and all the websites, they talk about, oh yeah, they legally terminated. They don't have the right to terminate. No. The General Assembly can't pass a law to eliminate the Gingiskin Reservation and divide it. That is illegal. So what is going on here? So when you look at Lisa and she's sitting up there quit claiming and claiming her land or whatever, fighting for her land, they're like, well, this was decided in 1813. It was terminated. Y'all were terminated. And, probably other Native Americans snubbed their nose down at us too. It's like, oh, well, y'all were terminated. They don't have the power or the right to terminate us. It's not knowing the law that makes you lose. It's not knowing the law that makes you a criminal. You're a criminal if you don't know your rights. You're a criminal if you don't know the law, because you're subjected to whatever lies they're telling. Right? When you don't know the law and you don't know your rights, then you're at the mercy of whatever lies they are telling you. You don't have any recourse. Right? Right? Hey, Suzanne. Hey, Chief. Hey, Rojak. You don't have any recourse when you don't know the law and how it applies to you. But I am here so that what I know, you're going to know, Chief. You're going to know, Suzanne. You're going to know, Rojak. And this thing ain't going to be pulled on not another one of us. Never, never, ever again. Never. So all these websites that talk about the Accawmackes being terminated, right? Subdivided. Look at this one. Subdivider, unable to withstand legal pressure and sold their land for profit. Baby, we can't sell it. We can take the land. We take the money, but you don't get the land, boo-boo. You just lost. If you brought land from an Indian, you just lost, y'all. Y'all lost. And guess what? Just the same way us not knowing the law has gotten us into a situation where we didn't know our rights as far as getting it back. That's the same way these colonizers, these people who have invaded our territory, y'all lose, because you had people that were doing title searches for you, right? They know the patents are there. They know the patents are there. See, terminated. What? It can't be terminated. That's absurd. It's a lie. All of those acts that said that it's not the authority of the state, and then they're going to say that the state terminated us. Who's lying? Like I said, what I said last night, either they're lying, they made up the lie in recent times, or they actually violated the law back in the 1800s. It's one or the other. Either they violated the law back in the 1800s, or they're just lying in recent times to just make sure that their land was secure. They made up a lie and said it was terminated legally, and spread it all over the internet, and all into the history books, and all into the daggone school, so they could feel safe and secure in possessing and sitting on our territory. But they're not safe and secure, because they should not be sitting on and possessing our territory. That is a corruption and a violation. It's just plain theft. It's plain theft, because our people fought hundreds of years ago to secure that for us, so we would not be in want, so we would not have lack. They looked out for us. Our ancestors loved us that much before we were ever a thought. Hundreds of years in advance, these wise, intelligent, advanced people did this for us. And we're not going to let these predators scare us off of daggone fighting for getting it back. Are you kidding me? Justice is prevailing. Justice is prevailing now, because their lies are falling apart. But I had to start with the first lie, which is, oh, it was terminated back in 1813. That's the first lie. That's a lie upon which this all sits. And so everything moving forward from that crumbles. You could never terminate an Indian nation. You could never terminate our ownership of the land. You can't defeat the land patent, and you can't terminate a nation of Indians, right? So what is really going on? Let's go to this. All right. Let's go to the next. Let's go to this. What is Jack A. Thornton III doing? What is he doing then? Why is he this is the same attorney that was in my civil case starting in 2021 for the same issue of Accawmacke Patented Land. He knows I've submitted the genealogy. I submitted the conveyance of land, right? All the records, all the laws that apply, the Intercourse Act, the Constitution, everything that supports the return of our land and shows the patent to be the supreme title. And I did clearly state this is an issue of patented land. This is not real estate. This is an issue of patented land. Not only did Jack Thornton, Leatherberry, and Elizabeth Haynes, the judge, they all took part in corruption. I had another judge for years who the brother just was in silence, submitting paperwork or motions and addressing motions back and forth. But at the end, the last 3 months, they put in this new judge, and she literally was newly appointed. Or I don't even know how she became a judge, because they do crooked things to make judges these days. Somebody say, yes, I know. I know. They do crooked things to make folks judges these days. And Elizabeth Haynes was suddenly a judge. And after she suddenly became a judge, after she was all her career, she'd been working in mediation. They put her in as a judge on my case and removed the other judge all of a sudden. And she was sitting there for 3 months, and then all of a sudden she just unceremoniously just dismissed based upon a statute of limitations. Well, that means she did ignore the laws that do apply to a patent, because there is no statute of limitations for a patent. Why did she use a decision such as that makes her look as if she was negligent in her role as a federal judge with regards to a patent, which, guess what, is a treaty? You failed to handle a treaty as a treaty, and you treated a treaty as real estate? But you see, what the powers that be, what Jack Thornton and all the rich land brokers on the eastern shore of Virginia thought is that she's not going to know any better. And once she's dismissed, we won't hear any more out of her. We won't hear any more out of that Lisa Cypress. That'll shut her up. She got dismissed. Everyone repeats that. Even even the court-appointed attorney that they forced upon me for a moment. You were dismissed. I'm like, she's corrupt as I don't know what. I filed the daggone misconduct on her. She is corrupt. That was a corruption of the law, that dismissal, because she dismissed a treaty like it was real estate. She didn't do it because she was ignorant, because she knows what a patent is. She dismissed it because she was banking on my ignorance. Everyone was. That's rude. That's disrespectful. That's bias. That's a human rights violation. That's a civil rights violation. And that's what they're doing. So what do I do with something like this? Well, I had to bring a motion for a bill of particulars for my friend here, Jack A. Thornton. So because he wants to, they want to go to court on March 31st. March 31st, everyone understand the court date. I want everybody to be in Northampton County on March 31st, should this actually come to pass, which if he has a brain in his head, it won't come to pass. But if it comes to pass, I need y'all all in Northampton County on March 31st, because this is an atrocity. And I don't know how he's going to answer my bill of particulars, because he does lie and he has no probable cause for the charges that he has placed against me for the legal claim of indigenous land. Okay? He has nothing. All right? So please provide evidence demonstrating that the 51 indictments that you as prosecutor filed are not being multiplicitous. 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 That's when they try to pile so many charges on you as to make it hard for you to actually mount a defense, create a defense, find someone to defend you, to create an extreme burden on the person that must defend these 51 charges. This is actually done corrupt. This is a corruption. This is a corruption of the law, being multiplicitous. And also, explain why you did not violate the Constitution and Virginia's unit of prosecution. The unit of prosecution states is against being multiplicitous. As a prosecutor, he is not supposed to be multiplicitous. And 51 indictment screams multiplicitous. This is supported in the case law, Brown versus the Commonwealth, 59 Virginia, 2012. Each statutory violation requires a separate act or distinct criminal intent. Distinct criminal intent to justify multiple charges. These are all the same action, the same intent, the same return of the same patented land. So for him to divide it and to make it into 51 indictments, that's multiplicitous. The court determines the unit of prosecution based on the language of the statute and the facts of the case. Number 2, please provide how bringing forth 51 indictments against Lisa Rena Cypress, you did uphold the Fifth Amendment Constitution, which prohibits punishing Lisa Rena Cypress multiple times for the same offense. Hello? Number 3, demonstrate according to Virginia law that you are able to prove that the 51 indictments are based upon separate acts and multiple distinct offenses, not variations of the same act. Excuse me. 4, provide legal justification for the prosecutor creating a prejudicial impact. The prosecutor charging 51 indictments did intentionally and unfairly prejudice the public at large. And you see how they published it in the paper, right? Because they invite that particular paper, that's that one that they got in their pocket. That particular writer, she comes to court whenever I'm there. And they did want to intentionally and unfairly prejudice the public at large. And the paper did defame me by being involved in this whole subterfuge of trying to create a prejudice the public at large and the jury against me as the defendant. The huge number of charges, along with the biased media coverage, created a lasting impression of guilt unfairly. We have to be able to defend ourselves, y'all. We have to know how to put them in their place. what they're doing to me, they are trying to create a precedent of this is not a thing. You can't claim your land. Well, it is a thing. And you cannot as violate my human rights and my rights as an Accawmacke Indian by trying to terrorize me with your court. Legal basis for a claim is key. Please show and provide proof that a valid Accawmacke Indian land patent interest, originally filed in 2021, did after 3 years of civil litigation in which Jack A. Thornton was part of the defense. How then in 2024 did the same patented land intent become criminal and malicious? So if it was civil, how did the same land patent intent become criminal and malicious? It's the same thing. It's the same action, the same patent, the same claim. Now all of a sudden it's criminal and malicious when I've been litigating on this issue since 2021. 2 civil cases. Now all of a sudden it's a criminal offense. Now let's talk about the charge that's been placed against me. The charge that's been placed against me, I'm going to just talk off the paper and just kind of let y'all know. The charge that's been placed against me actually is a charge that they created because folks were putting liens on like judges and police officers and stuff like that and court clerks. And it's a new law that stops people from actually filing liens against judges, attorneys, court clerks, whoever, against court official, government officials. That's what that was. That's what that actual law is. It's not really designed for land quit claims or anything like that. It's really designed for people placing liens on government officials. That's why it's a very new law. It was just done, I think they just made that law either the beginning of this year or last year. It's a real new one. So yeah, the law that he used, malicious liens and encumbrances, that's not even used. It's never been used for any kind of land issue, let alone a quitclaim issue. So there's another wrinkle in this that people may not be aware of. That law is a new law. It is not designed for real estate. It's actually designed for, folks who put liens on public officials. That's what it is. Number 6, the outcome of the 10/16/24 preserved community civil case. Now that's a case in which we quit claim on this development that's called Bay Creek or Preserved Communities, which is a beachfront golf community of, some luxury homes and townhouses. And one of the houses, they claimed they were unable to sell $1 million house because of the quitclaim. But in reality, that Preserved Communities has a bunch of criminals that are running it, and it's not doing well because historically this property has already been under like 3 different ownerships. It should have never been developed because it is on patented land and it's pretty much cursed, okay, because of it. So basically, the person that was one of their partners actually went to jail for tax fraud. They were trying to give people tax breaks and they were all doing all kinds of illegal, whatever shit to try to give these property owners or whoever tax breaks, and they let their partners take the fall. And so, these partners weren't even from the Eastern Shore. They were from other places. They didn't know anything about the intricacies of the rules and how they told them they probably told them, oh yeah, it's cool. We do what we do over here. It's Northampton. We run this, So, but then when the chips fell down and the federal government was on their butts, they let these 3 dudes go to jail, and they're in federal prison. This guy's 77, going in federal prison for 25 years. Now they probably let him keep his coins. He's a billionaire. They probably are, he probably feels like he's being, compensated for his jail time. I don't know, because I reached out to him and he hasn't responded to me. So obviously he's still in connection with them, and his company is trying to attack me that he started what is it called? Catamount. So they're all in cahoots and they're all attacking me, cross states and all kinds of stuff. This is a big malicious syndicate, real estate syndicate. That's why I'm being, the main reason why I'm being prosecuted is a real estate syndicate is angry. Well, anyway, they filed this civil court case in October of 2024. They said that this house would, had a problem because of the quitclaim. I said, excuse me, but you have partners that just in the beginning of the end of the last year, like 2024, the beginning of 2024, went to jail for tax fraud. So how they're billionaires and millionaires. So why are you suing a broke 5031C? First of all, 5031C is the wrong entity. A 5031C can't own land. A 5031C don't have a heritage. They don't have ancestors. They can't claim their indigenous, their Indian ancestry. They are the wrong entity. You're suing the wrong entity. The judge ignored that. He just ignored me saying that. It's really rude. Anyway, but what I also said was, in addition to that, why are you not suing your rich partners who went to jail? They're billionaires and millionaires, and you're suing a broke 5031C. That makes no sense. If anybody damaged your reputation and an ability to sell these houses, which you had a problem with it anyway, because you're over 50% vacant. See, you got to know. You got to research. Oh, you're over 50% vacant and you're blaming me for your lack of sales? You've been over 50% vacant. They can't even rent them. They can't even rent them. And yet they're trying to daggone sue me for $300,000. I said, no, sir. No, sir. As a matter of fact, you would do better if you would actually donate some houses to the Accawmacke Indians on that property. That would be a real tax, a true tax write-off, instead of whatever your partners were doing for years. I don't know what that was, but this is our land, and this issue remains. And so they actually settled to have the quitclaim removed. They said, okay, we just want the quitclaim removed. I was like, you want the quitclaim removed? But the issue is still there. It's on patented land. Indian patented land. You don't own it. So you can't really sell it. The quitclaim being gone doesn't change the issue. It's patented land, and all you're doing is passing on this issue to an unsuspected buyer. And I know they say, let the buyer beware, but that's really unethical, I said. That's unethical. So here I say that if this was a frivolous, fraudulent undertaking, then the entire big corporation of Preserved Communities would not have filed a civil charge if it wasn't a legitimate claim. They would not be able to assert any kind of damage or in any way. If it was just frivolous, our claim is not just legit. But if you understand the patent, if you're claiming a patent, we're the primary owner. They're secondary. They don't own it at all. The only true title is the land patent. So who actually is the encumbrance? They are. They're the encumbrance. They're the ones who should have criminal charges. You are creating encumbrance on our patented land. Not only that, you're just up and up stealing it. So what I said here, let me get back and read it if I would, is evidence that the Accawmacke's title holder can demonstrate that their title is valid. And it may create a cloud. It is not frivolous or malice encumbrance. Instead, it's a legitimate legal assertion, not a criminal assertion, and must be adjudicated in a proper forum, typically federal court. Please provide the legal precedents and law which supports you prosecuting this Crown patented land issue, where there is a court-given valid title, as a criminal circuit court case, rather than removing it to a federal case, as the defendant filed for removal to federal court back in June. I filed for removal to federal court. It's not criminal. It's legal. It's not fraudulent. It's an actual, it is actually a claim of justice. It's a justice claim. It's return of stolen land. And it is an initiative to seek justice. And it's a human rights issue that they're trying to turn into something that is tawdry and fraudulent. And that is a mischaracterization of what is going on. Jack A. Thornton, you were assistant attorney of Northampton as part of the defense of the civil case for Lisa Cypress filed against Northampton County Board of Supervisors and PNC Bank. You know that Lisa Cypress has been peacefully, publicly protesting, giving newspaper interviews, placing no trespassing signs, posting legal notice, litigating, and filing quitclaims for her Accawmacke Nation since 2021. So then, how did you, Jack Thornton, on May 2024, suddenly prove that what has been peacefully quitclaimed since 2021 rose out of a malicious intent to deceive, harm, or unlawfully interfere with another's property? That's not what it is. Actually, it's not even another's property. The issue is it's not their property. And it can't be, because it be on patented land. Especially given the fact that valid title does not exist as proven in the Preserves Community versus Accawmacke Indigenous Indians case on October 2024, October 16th. So see, stop it. Number 8, Jack A. Thornton, are you aware that criminal charges such as malicious incompetence or fraud require proof of intent? Proof. He needs to provide proof of intent to harm or unlawfully interfere with another's property rights. Please provide that evidence. How can it become malice or deceitful or unlawfully harming when you've been civilly doing this for years? Make that make sense. Prove that provide evidence that evidence and legal standing, proving that the Accawmacke Indian property issue of filing quitclaims for Accawmacke Crown Patented Land, which is identical to the non-criminal quitclaim filed in May 2021, is now suddenly a criminal offense. So the same quitclaims that were filed identical in 2021 are the same quitclaims that were filed to reclaim land in 2024. So how is it now a criminal offense? Corruption. We got corruption from the title companies that sit up there and say, oh yeah, it's all clear. Go ahead, build your house. Oh, it's okay. Go ahead, buy this. It's good. When at the same time they're talking about, oh, look at the lovely patents in the courthouse. Oh, look at the old historical Indian patents. Isn't that cute? Oh, isn't it quaint? Oh, when they know these patents exist. They failed to warn buyers. They failed to warn builders that these patents do cause an issue. That these patents are forever. Warning. What makes them lie about the patents? What makes them deceive about the patents? Greed. The title companies, the clerks, the lawyers, the judges, the government officials. Greed. Hiding behind the colonial truth about the Accawmacke Indian land patents. They're hiding. They're hiding behind them. They're deceiving people. And this kind of corruption has to stop. And I don't know how they look their family in the face. I don't know how they pet their dog. The dog that should be running away. The dog should be running away. The other very racist dog. They need to run away from her. What the world? How? It's disgusting. It's disgusting to be that. Why? Why are you that corrupt? It's time for justice. You're sitting on the wrong side of history. by you all being this corrupt. Because, see, you could say, oh, the ancestors, this was done in the past. Oh, it's not us. We're the good guys. Our ancestors, get over it. It happened in the past. No. Now we all can see. The entire world should see. Share this. Take snippets of it. Put it on TikTok. Put it all over the place. The world can see that this corruption is not historical. It's right in our midst right now. You have the opportunity to be on the side of justice, but they choose to be on the side of corruption, to the point that they are going to arrest and jail a woman for doing what she knows is right and has been doing the same thing in the same way for years. But you want to scare her. You want to terrorize her. You want to use multiplicative charges against her, make it impossible for any lawyer to want to defend her because it's too many charges to make her feel like, I don't know what I'm going to do. I can't handle it. Oh, I promise I won't do this no more. That's what they want. I'm so scared. I promise I never going to do this again. That's what they expected me to do. Well, they're wrong. And there's a lot of people watching. There's a lot of people learning. And after me, just within the Accawmacke, there'll be another and another and another and another. Because once the truth is out, you can't shut it back up with your lies. You can't tell enough lies to destroy the truth. Please describe how Lisa Cypress is personally criminally charged for filing quitclaims as representative of her Accawmacke Nation, especially being that all quitclaim documents clearly detail that the claims are being made directly to the Accawmacke Nation, not Lisa Rena Cypress. In addition, the quitclaims were made in connection with the Accawmacke Nation supreme title held by Crown land patents, not by personal title assumed by Lisa Rena Cypress. Provide legal justification for personal criminal charge against Lisa Rena Cypress when the forever title is held and claimed by the Accawmacke Nation. Explain that. Number 11. All 29 quitclaims are Accawmacke Nation claims. In fact, only one quitclaim bears Lisa Cypress's name, and that one quitclaim for Switch Beach Road. The property was published in legal notice and has a photo image, and the photo in the paper with the Accawmacke no trespassing sign. What legal justification does Thornton have for prosecuting Lisa Rena Cypress as singularly responsible criminal entity and for malicious encumbrances of 29 properties? Please show proof of the intent to deceive, defraud, or harm when the Accawmacke Nation did legally send letter, give opportunity for objection, announce, and post the Accawmacke justified plan recovery of stolen Accawmacke Crown Patented Land. Public notice. Published in a paper. Signage. Number 13. Explain how Lisa Cypress did create malicious encumbrances when on October 16th, Preserve Communities did file civilly to remove the quitclaim. The civil case does prove that Lisa Cypress did not at all commit a malicious fraud or encumbrance verified by the merit of the quitclaim. Prosecutor Thornton III provide proof that Lisa Cypress having a valid claim was motivated by intent to defraud or malicious intent. The fact that Preserve Communities litigated to remove the Accawmacke quitclaim and remove the demand for $3,000 does prove the validity of the quitclaim and a lack of malice and criminal intent. The civil case verifies the Accawmacke interest in the property is valid. A valid quitclaim would require the removal by a large land developer such as Preserve Communities. Please show and prove that the damaged injured parties for the 29 quitclaims have superior Crown Indian land title patents that is forever. Where are their land patents? The 29 property people Where are the land patents? Where's their crown patent that renders all other titles void? Because our title renders all other titles void. Where's theirs? Show and prove just how the 29 quitclaim properties have title that provide title superior. Where's that? Show and prove that your right to validate laws which protect Indian land, patented land. Prove your right to violate constitutionally protected Accawmacke Indian land. Thornton, where's your right? Number 16, please show evidence. Oh, I'm sorry. I skipped. Please show evidence that these quitclaims of the Accawmacke land has been discussed publicly, and published in the newspaper in a variety of ways is done for malice. Please provide evidence that this criminal case does prove. Defendant has filed an encumbrance knowing of its falsity. Both the civil case of 373, the prosecutor Jack Thornton defended for 2 years, and the civil case of 2024 that defendant Lisa Rena Cypress did claim in good faith to seek justice in return of stolen patented Accawmacke land. This is a good faith effort. Please prove of known falsity of quitclaim in it. Please provide proof of the state court as jurisdiction in federal land patent and show why the request for removal to federal court has been ignored. How do you have jurisdiction over federal land patent in this court? And I did request for removal back in June to federal court. What's happening? Please show evidence that you as an assistant Commonwealth Attorney and defendant in the case is not in any way biased after being the Northampton Assistant Counsel and prior civil case involving the same quitclaimed patented land. Show that you don't have bias, Thornton. Please also explain why the recusal, because I did apply a recusal for your removal as prosecutor in this case, because of your bias, has been ignored. The recusal has been ignored. Why? Show that. Number 22, please explain why you can prove that you did not seek to intimidate and coerce into a plea deal with excessive number of 51 indictments. Those 51 indictments are to cripple someone, to coerce, to intimidate someone. Please prove that it wasn't. What was the intent? Please provide legal precedents and law supporting 51 excessive number of indictments against Lisa Rena Cypress, a master's degree RN with no prior criminal record, who has been peacefully reclaiming stolen land since 2021. Why would you have excessive charges against someone who has no prior charges? Explain that. These are all the things that no attorney was bringing up for me. Please provide proof and evidence that the excessive 51 indictments were not intended to overwhelm. They do the excessive charges to overwhelm the defense. That is the tactic. 51 multiplicitous charges are used to overwhelm your defense. That was the intent. And it is a violation of, going back. It is a violation of Virginia's unit of prosecution. Okay? That's what it is. It's a violation. Yep. Excessive number. Intimidate, coerce, but also to overwhelm the defense. Number 24. Number 25, in addition, prove that the 51 indictments were not designed to make it impossible to afford to hire a reasonable defense. This is another thing that it does. You got 51 indictments you can't afford a reasonable defense. Ah, that's malice, man. That's malice. Yeah, you want to talk about being malice prosecution? This whole thing stinks and reeks of it. Malicious prosecution? Yeah. Unable to afford a reasonable defense. Overwhelmed the defense, right? You are biased. You was on the defense of the daggone civil case, and now you're prosecuting something that was civil twice. All of a sudden it's criminal. It's not adding up. Provide legal grounds on which the prosecutor did split similar allegations. He split similar allegations into separate counts to intentionally maximize punishment and increase the potential penalties. He maximized punishment and increased the potential penalties. That is a violation of his position and his position as prosecutor and the rules that do apply to prosecutors. He's violating them. Prove that as a prosecutor, you did not punish through process. Punish through process. Punish through process. The words that tell you what they're doing, the secret language that they speak. He is punishing through process. Jack A. Thornton is punishing through process, creating a heavy burden of defense, many indictments, financially, mentally, and emotionally, burdening the defense. And this is of a person who's never had any criminal charges. So the fact that you would actually punish through process a person that has no criminal background makes you look like an animal, makes you look vicious. Really, Jack, it makes you look vicious. It makes you look vicious. What is this, some kind of KKK action? What is this? What is it? Why are you being so vicious? Yeah, I know y'all are afraid you're going to lose your land, but you know that I showed you that this is not about being vicious, not from the Accawmackes. I have said it over and over again. We quitclaim vacant vacation properties owned by mostly people that live in other states. Vacant, for sale, or for rent vacation Airbnb properties. People don't even visit half the time. And not putting anyone out of their home, their family homes. There are huge houses on our Accawmacke plat that belong to us. None of them were claimed. Right across from PNC Bank, there are houses next to PNC Bank that are on our Accawmacke Patented Land. Very low-hanging fruit that could have been claimed. They were not. Why? Because we're ethical, y'all. Because we're ethical. Even though we have a right to have that property, it is ours. We went outside of that on intention. Some of us didn't want to. Some of the Accawmackes were like, take it all. Some of the Accawmackes feel like that. Some of the council take it all. But we acted with prudence, and we acted with humility, and we acted with ethics, and we acted with a fair and loving spirit, because that's what we Accawmacke Indians have. But you're being vicious. You don't care. You jailing a daggone nurse, 30-year nurse, freaking throwing all this, punishment by process at her. Just disgusting. I need Jack to prove that there was no violation of the U.S. Sixth Amendment standard, in which 51 indictments did fail, informed Lisa Cypress of the nature, cause of accusation. This is especially true given the fact that Lisa Cypress was not jailed and prosecuted on the 2021 claim of her Indian land patent properties. Prove that the charges were not vague. Show that the dates and time and witnesses of all offenses. Describe the criminal conduct. Please state the statutes and laws that were violated. Jack Thornton. 29. Prosecutor Jack Thornton, referring to the defendants having a worldview. A mental capacity hearing was done before I was even. I have yet to be explained my charges. He has yet to stand in a hearing and state that, oh, these are your charges. This is what they are. This is why they are. My charges have yet to be discussed or explained to me at all. They immediately tried to scare me with a mental competency hearing, to act like I didn't have the competency to understand my charges. Well, they never explained the charges to me, but I understood them. They were never explained. Find that in the court records. Find that in the daggone transcripts where Jack Thornton did explain the charges in detail. Or no, that hasn't been done. It hasn't been done. And then for him to stand side by side with my forced upon me court-appointed attorney, talking about I have a strange worldview and trying to convince me that the Accawmacke need to seek recognition. What does the Accawmacke have to do when the case is against Lisa Cypress, and they don't even mention that I'm Accawmacke in the charges? It's like I'm just some weird whatever ninja going out there and taking up land. They don't even state that I'm an Accawmacke Indian in the charges. It's just Lisa Cypress. They make no reference to it. But yet in court, they're talking about, oh, the Accawmacke needs to, talking all Accawmacke, calling me chief and talking about the Accawmacke in court. But on record, they deny it. They do make me look like to be some kind of weirdo sovereign citizen. He shows to be biased, and he needs to prove that it does not show bias. Why does the prosecution has not identified the name or named any co-conspirators? Many of my charges beyond the 29 are for co-conspiracy. Where's the evidence? Please provide evidence and justification for charging multiple indictments for conspiracy without supportive evidence of any conspiracy or for any multiple instances of conspiracy. Prove it. Show and prove. The excessive 51 indictments suggest overcharging, an attempt to exert pressure on the defendant. Provide proof that that was not the intent. We're on number 32. Oh, I kind of. Who be injured? I need them to list all the injured, damaged parties for the indictments. Please show proof of damages. So all the details of the defendants. Show the dates and place of social security numbers for the 51 indictments. When I transferred it to this medium, the renumbering kind of jacked up and I didn't fix it. The date of incident, the time of incident, the name of the injured parties, name all 29 quit claims and other damages. Give me proof. Since this is such a thing. Since the crime was committed, name all the damaged parties. Let's see. Show me how they were damaged. So there you go, y'all. This is what it is. This is what it is. This is, this is what they're trying to do. They're trying to make me out to be this criminal because I guess they're trying to scare this away. They're trying to scare everyone. Oh, don't you never like Miss Bethy. Oh, Miss Bethy. Oh, she listened to it more and she got herself in trouble. Don't y'all never do nothing like this. You know, acting like she's birthing babies. We claim no land. Stop being scared. Scared people can't do anything. Don't let nobody terrorize you. That's ridiculous. Fear cannot be a part of this. And if you don't understand the law, you don't need to be going around flapping your wings, screaming at everybody else that they need to be afraid. You need to read. You need to get yourself familiar, and you need not to be afraid. They have to corrupt. The fact that they have to cheat and they have to lie in order to win shows the level of desperation. And yes, it is malicious. It's malicious prosecution. This is what they are participating in. And that the fact that they are so desperate that they are lying, so desperate that they are operating outside of the law. They are corrupting the law. They are corrupting their rules of prosecution in order to do what? To stop this. They can't stop what is time for. They can't stop what justice that will prevail, because this is prevailing. Justice is prevailing, and they can't stop it. They cannot continue to be evil. They cannot continue to corrupt. And you got to look out for these people that are pretending that you're you and that they're on your side when they're not on your side. You got to be careful to understand that you have to stand 10 toes down together. And you've got to understand that they will seduce your family and friends to try to put you down. They'll use whatever means necessary, and people will come to try to undo what you're doing, but they won't win. And they're going to fall down just like these people, just like these criminals, just like these corrupt officials. They will fall down because you can't stand on the side of what is corrupt, what is unjust, and win. It's not that party. It's not that time. Our ancestors did not hold the bag for us, did not daggone keep this thing for us for all these hundreds of years for us to fumble. No fumbling allowed. This is a time to win. We are prevailing. Jack A. Thornton, how do you look at do you have children? Do you have dogs? How do you even look at them? Like, how do you actually walk outside and be like, yeah, I'm holding my head up. I'm a great attorney. No, you need to be ashamed of this. This is sad. This is historically a sad Benedict Arnold weird shit. This is weird. It's sad. It's pitiful. It's disgusting for someone in 2025 to be doing this to the known indigenous people who have been harmed all these centuries. For you to add injury to a people who have been massively injured. How do you live with yourself? Like, seriously. You know, I don't know how anybody looks at you and say, wow, you're doing great. No, you're not. There's got to be people that find you to be pretty daggone embarrassing in your family. There's got to be, because this is really a sad thing. You know, you and the entire group of people, Elizabeth Haynes, daggone Tracy Johnson, Consuela Rodriguez, Consuela Gonzalez. These people are pitiful. That's disgusting what you're doing. What you are doing to keep the indigenous Accawmacke people from what has been stolen from them is a disgusting thing. And you're going to go down historically as the villains. And the villains that you aren't going to win. Because the time is now, and justice is prevailing. It is prevailing. 2025, baby. Justice is prevailing. Y'all, March 2025, 31st, Northampton County, Virginia. If Jack Thornton is ignorant enough to have a court date on that date, we're going to be there in big numbers, huge numbers. All the indigenous people show up, and let's pack the damn building, pack the daggone parking lot, pack the daggone yard. Let's pack it like it's a concert. Let's pack it like it's a concert. Anna.